Dear students, subscribers and the viewers, welcome to the IAS Mentor. This would be our lecture number 26 in the series Indian Polity. The very objective of this particular series is to provide a broader idea on the subject Indian polity, and we will also cover in the process the entire Constitution of India and also some of the relevant books, especially LAXMIKANTH, which is considered to be an important book for the civil service examination, will be covered in depth in the series that you are going to do. This series would go on for another 3 to 4 months. So students, if they follow it regularly, it will be really beneficial to them, and it will be really beneficial for the students, not just in the prelims but also for their analysis that they can do in the mains examination as well. So with that, I'll enter into the next lecture, and in this lecture I would continue from wherever I left in the previous lecture, because we are looking into Article 16 of the Constitution. So in continuation of what we have been seeing under Article 16, we will just move to the other articles, because in our previous lecture we have not completed it, so probably we will complete that. But before I start, let me just have a little bit recap of what you have seen in the last class. So in the last class we have started Article 16, and in Article 16 we have seen that the general principle is that the state shall not discriminate when it comes to employment under the state or when it comes to public employment. But it doesn't mean that the state cannot discriminate at all. It only means that the state cannot discriminate in certain areas. So the state shall not discriminate when it comes to public employment on the grounds of religion, race, caste, sex, descent, place of birth, residence, or any of them. This is what the article says. So it would be a fundamental right of every citizen that the state shall not discriminate on these grounds when it comes to what is called as public employment. So that is quite clear in Article 16. But however, Article 16 is not only following the principle of equality before law, whereas Article 16 class 1 and Article 16 class 2, they are based on the principle of equality before law, but there are other articles that you will have to understand. Article 16 class 3, Article 16 class 4, and in fact today we will discuss 4A, 4B, 5 and class 6 as well under Article 16. They are all based on the principle of what is called as equal protection of laws. It means it is not that they are all equally placed. It means that it is not that there shall be no discrimination. It only means that there cannot be discrimination when people are equally placed. So again we have seen what is Article 16 class 3. Article 16 class 3 confers special powers upon the state to provide for residence as a requirement when it comes to employment under the state, which only the parliament has the power to make law. We have seen that yesterday. Article 16 class 4, what you have understood, Article 16 class 4 confers powers upon the state to make special provisions for reservation from the backward classes when it comes to public employment. So based on which the government started giving reservations, and from 1990s they also started giving reservation to the other backward caste in public employment, which were later challenged in the Indira Sahni case. But the Supreme Court has upheld this particular reservation, but of course with certain caveats, means certain conditions, that while giving reservations the non-creamy layer should only get the benefit, the creamy layer should be excluded. While reservation is allowed, reservation in promotions cannot be extended. So based on these conditions, but however in principle the reservation was upheld by the Supreme Court. But one change that they brought in is especially what is called as that the reservation in promotion was struck down. And because the reservation in promotion was struck down, while the government was allowed to give reservation in the initial recruitment, but they are not allowed to give reservation in what is called as a promotions. Of course, the government of the day was not happy with this particular judgment. So in order to nullify this particular judgment, in order to overrule this particular judgment, what they have done is that they have made a change in the constitution, or in other words, they have amended the constitution and they have inserted what is called as Article 16 class 4A. Now, why the Supreme Court in the Indira Sahni case said that there is no scope for reservation in promotion, while there is scope for reservation in the initial recruitment, because there is an enabling provision to that extent, but there is no enabling provision in the constitution that would allow the state to give reservation in promotions. If that's the argument that is made by the Supreme Court, the Parliament thought that we will create that enabling provision. We will enable that in the Constitution because we have the power to amend the Constitution. So the Parliament used its power under Article 368. They amended the Constitution and they brought in a new article under Article 16, that is Article 16 Clause 4A, which would now enable the state to give reservation in promotions as well. So that is basically what Article 16 Clause 4A is all about. So try to look at here what is Article 16 Clause 4A. Article 16 Clause 4A provides for what is called as reservation in promotions by the state in favor of the scheduled caste and scheduled tribes. But however, the amendment that was brought in into the Constitution, and by which amendment it was brought in? It was brought in by the 77th Constitutional Amendment Act in 1995. So you can understand the chronology. So Indira Sani case was in the year 1992, and subsequently based on the Indira Sani case in 1992, the reservation in promotion was struck down. As a follow-up of the Indira Sani case, 77th Constitutional Amendment Act 1995 was made. Article 16 Clause 4A was inserted. They brought in reservation in promotions as an enabling provision. But however, this time when the state brought in this Article 16 Clause 4A as an enabling provision, allowing for reservation in promotions, they did not allow for reservation in promotions for the backward community. For whom they have allowed for reservation in promotion? They have allowed for reservation in promotion only for the scheduled caste and the scheduled tribe. So this is basically what you'll have to understand. So the scheduled caste and the scheduled tribe community, they are allowed to have reservation in promotions as well, and to that extent the state can make policies, because to that extent Article 16 Clause 4A acts as an enabling provision. It enables a state to make what is called as reservation in promotion. So this is the first thing that you have to understand. And after that, the reservation in promotion started happening. But however, this reservation in promotion and the constitutional validity of this reservation in promotion was challenged in the Supreme Court in a case which is called as a Nagaraj case. So subsequent to this amendment was made, this constitutional amendment was challenged in the Supreme Court that it is violation of what has been told by the Supreme Court in the Indira Sani case. So the Supreme Court looked into this particular matter, and in the Nagaraj case they also upheld the validity of reservation, that is reservation that is given to provisions, but with certain conditions. They have brought in 3 conditions. One is test of backwardness. So I'll just let you know as to what they are. So first is test of backwardness, and the second is on the grounds of inadequate representation. So what is the second thing? Inadequate representation. And of course the third thing is that the administrative efficiency not to be compromised. So the efficiency not to be compromised. So these are the 3 conditions that was brought in by the Supreme Court in the Nagaraj case. So what does it mean? The Supreme Court in the Nagaraj case is of the opinion that we have no problem in giving reservation in promotions, because to that extent there is an enabling provision, and we would declare that this Article 16 Clause 4A to be constitutionally valid. But however, before giving reservation in promotions to the scheduled caste and scheduled tribe, what the state has to ensure is that the people who are getting reservation in promotions from the scheduled caste and scheduled tribe, the state has to ensure that they really deserve the benefit of reservation. That means they really come from a backward community. So that is what is called as test of backwardness. The second thing is that while you give reservation in promotions, we are not against that, but the inadequacy of representation has to be proved. What does it mean by inadequacy of representation? Which means that there is a need to give reservation in promotion because from that particular community, people in that position, in higher positions, are not there, and because they are not represented in the higher position, in order to enable their representation, we are giving reservation in promotion. To that extent you should have the data, or to that extent you should be confident enough, or to that extent you should be satisfied. So that is what is inadequacy of representation. And the third thing is that while reservation promotions can be given to the scheduled caste and scheduled tribe, because reservation in promotion is not strictly on the basis of merit, it is given to people belonging to certain community. So the Supreme Court said, while you can go ahead and give reservation in promotions, but make sure that it is not going to in any way affect the administrative efficiency. because here the reservation in promotions is not strictly on the basis of merit. So make sure that the merit is not make sure that the efficiency of administration is not getting affected. Without affecting the uh, administrative efficiency, you can go ahead and give the reservation. So we don't have any problem with that. So this is the basic conditions that has been brought in by the Supreme Court, that is test of backwardness, inadequacy of representation, and of course the last thing is efficiency is not to be compromised. With these conditions, the Supreme Court upheld the reservation in promotion. But again, this was challenged in certain other cases in the Supreme Court, and this test of backwardness has been now done away with. Because subsequent case, which is also called as a Jarnail Singh case, if you want to remember, you can remember, but not very important. The Supreme Court said, see, the scheduled caste or the scheduled tribe community is not a homogeneous, it's not a heterogeneous community, it's a homogeneous community, which means that they all belong from the same group of people, or they are backward to the same extent, and hence they are historically exploited and backward. So there is no need to do any test of backwardness, so that is not required. So apart from the test of backwardness, the other two conditions are to be satisfied, that is inadequate representation and the administrative efficiency not to be compromised. But having said all these things, the Supreme Court also said it is the responsibility of the state to make sure that only really deserving people are getting the reservation in promotion. So that is one aspect of the judgment which is to be closely looked upon. So that it makes that only the deserving people has to get the benefit of reservation. So that has been brought in as a part of the judgment. And to that extent, today the reservation promotion is upheld, and that is the law of the land. And who can get the reservation in promotion? The scheduled caste and the scheduled tribe can get what is called as reservation in promotion. In addition to that, Article 16 Clause 4A was again amended, and there was a principle what is called as a consequential seniority. A principle of consequential seniority was also inserted into the constitution. So first, when Article 16 Clause 4A was inserted, there was no principle of consequential seniority. They only brought in what is called as reservation in promotions for the scheduled caste and the scheduled tribe by the 77th Constitutional Amendment Act. Subsequently, it was amended, the same article was amended, and by 85th Constitutional Amendment Act in 2001, consequential seniority was also brought in. So what is this consequential seniority? Consequential seniority concept is very simple. So first we understood reservation in promotion. Reservation in promotion means, suppose let us assume there are two candidates A and B. A is from general category, B is from a reserved community. Say let us assume scheduled caste or scheduled tribe, whatever be it. And they both are in the same grade. Suppose let us assume they are both on the same grade, but A is a senior. A person from the general candidate is a senior, let us assume. So let me put it like this. So let us assume A is here, B is here. A is a general category candidate, scheduled caste or a scheduled tribe, but let us assume he is 6 months senior in terms of the joining. So who is senior? 6 months senior, A is the senior. But right now they are in the same grade. So there is one vacancy that is here for the higher position, and this vacancy is only for the reserved category. So automatically who will get the promotion? B will get promoted because of the concept of what is called as reservation in promotions. So he is getting promoted because of the reservation. Now, although A joined before B, now B is getting promoted because of reservation promotion. Now when B goes to this particular position, B will become the senior of A. So this is because of the promotions. Now what happened earlier? Now let us assume that this is normally what will happen. I'll come to consequential seniority, but let me explain you before. Before the principle of consequential seniority, although B got promoted before A, and thereby B becomes senior, but let us assume again there is a vacancy for the general, and A also get promoted to this particular same rank. When both A and B come to the same rank, although B got to the senior rank first, but later A also went to that particular rank. The moment A also got promoted to the same rank, then A will automatically become the senior, because by virtue of the joining in the service, A is a senior. So this was a rule that was followed before consequential seniority. I'm just explaining it. This was a rule that was followed before consequential seniority. So before consequential seniority, what is the concept? If there are two people And if one person gets promoted by virtue of reservation in promotions, and then the other person also get promoted after some time normally, then who will automatically become the senior? The person who joined the service first will automatically become the senior. This was before what is called as consequential seniority. Now, what is the principle of consequential seniority? Now, A and B are in the same rank, but A joined the service first, B joined later. But because of reservation in promotion, B gets promoted first. Although he is junior, B gets promoted first. And then after some time, A also get promoted. Although A may get promoted, but B would still continue to be the senior because B got promoted to the senior position first. So then B would continue to be the senior of A, and that is as a result of what is called as consequential seniority. That means as a consequence of reservation and promotion, B will retain the seniority. That is basically consequential seniority. I'm sure that it is quite clear to all of you. So Article 16 Class 4A basically brought in what is called as reservation and promotions for the scheduled caste and scheduled tribe, and then subsequently it was amended. It also brought in the principle of what is called as consequential seniority. So the constitution did not stop here or the parliament did not stop here, and then they inserted one more article in Article 16, that is Article 16 Class 4B. Article 16 Class 4B was inserted into Article 16 by way of what is called as the 81st Constitutional Amendment Act, and this was also in response to the Indira Sani case. Now, take a close look into the Indira Sani case. I said that the Indira Sani case also brought in what is called as a 50% rule in promotion. And the Indira Sani case said that this 50% rule will also apply in case of what is called as carry forward rule. In the last class itself, I explained as to what is carry forward. Now, carry forward means whenever the seats are reserved to a particular category of people, be it scheduled caste, scheduled tribe or the other backward caste people, then if the people are not recruited according to the vacancies that is reserved for them in a particular year, the remaining vacancies are carried forward to the next year. But when they are carried forward to the next year, the Supreme Court in the Indira Sani case said, you can carry forward, that is not an issue, that the government can carry forward, that is not an issue. But that carry forward vacancies along with the new vacancies for that particular year, a given year, should not breach the 50% limit. Now, in this way, what happens, if you mix up the carry forward vacancies and the vacancy for a given year, it will automatically be more than 50%. And then because the reservation cannot be more than 50%, it ultimately led to some kind of loss for the people from the reserved community, because their vacancies cannot be more than 50%. So ultimately, these will become what is called as a general seats. So in order to avoid that, the constitution was amended by the parliament. They brought in what is called as a specific article, which is Article 16 Class 4B, wherein it said that any carry forward vacancy is not to be merged with a general vacancy, or it's not to be merged with a vacancy of a given year. So it will be considered to be a separate class of vacancy, and whatever is a vacancy for that particular year, that will be seen as a separate class of vacancy. For example, let us assume in 2024, let us assume that there are 1000 vacancies. And out of those 1000 vacancies, for example, let us assume, for just example, let us assume 500 seats are reserved. 500 seats are reserved, and let us assume 500 are general vacancies, right? Of this reserved vacancies, let me come this side, of the reserved vacancies, which is 500, let us assume only 250 are filled. That means another 250 are vacant because the suitable candidates are not there, so it lied vacant. Okay, so this is the understanding you should have. It lied vacant because there are no suitable candidates who are there. So let us assume in 2025, again there are 1000 vacancies, and in this let us assume 500 or for general and 500 let us assume for the reserved community. Now 250 are vacant, so you are bringing this 250 and you are merging it here. So when you add up 250 plus 500, then it becomes 750, and then 500 for the general, so total 1250. So if you sum it up, it becomes 1250, and out of 1250, if you have to reserve 50% of the seats, then it will be approximately what? It will be approximately only 625. Only 625 seats can be reserved, but 500 is already there, and then you are carrying forward another 250. you cannot reserve the 750 seats. Because the Supreme Court in Indira Sani case said you carry forward the unfulfilled vacancies, but at any cost, the reservation should not be over and above 50%. So, in order to avoid this particular ruling that was given by the Supreme Court, the Parliament amended the Constitution. They inserted a new article, that is Article 16 Class 4B, wherein they said that the unfulfilled vacancies will not be merged with a vacancy in a given year. So, this will remain as a separate class of vacancy. It is a separate class. We will not merge this with this particular vacancy. So, in the year 2025, out of 1000 vacancies, 500 will go to the reserved, 500 to the general community, and there will be separate recruitment for these 250 seats. It will remain as a separate class of vacancy. So, it will not be merged with a vacancy in a given year, so that the benefit which is to be given to the reserved community will go to the reserved community. So, that is the idea of this particular amendment that was brought in by the 81st Constitutional Amendment Act in 2000. And to that extent, the state can make policies as to how to work out this carry forward vacancies and how long they can keep this carry forward vacancy. So, as of now, the carry forward rule may apply to the scheduled caste, scheduled tribe as well as the other backward caste, but the state has not made any policy in this regard for the other backward caste, but for the scheduled caste and scheduled tribe, the state has made the policy. So, the scheduled caste community and the scheduled tribe communities, they are benefiting out of this particular rule that is made by the state under Article 16 Class 4B, or the policy that the state has made under Article 16 Class 4B with regard to the carry forward policy. Okay, so that is basically you will have to understand. So, now we will move to the next article, that is Article 16 Class 5, and of course, there is one more article that you have to cover under Article 16, that is Article 16 Class 6. So, by the time I go to Article 16 Class 5, I am sure that you are all clear about the concepts of what is the reservation in promotions, what is the position of reservation in promotions, what is consequential seniority, and of course what is called as carry forward rule. It should be quite clear to all of you. So, now come to the next article, that is Article 16 Class 5. Now, what is this Article 16 Class 5? Article 16 Class 5 is again based on the principle of what is called as equal protection of laws. It is not based on the principle of equality before law. It says that whenever a recruitment is done to any religious institutions or an institution run by a religious denomination, then in that particular case, if any particular vacancy in that particular religious institution is reserved for a people from a particular religious community, would not be seen as violation of Article 16, even if that recruitment is under the authority of the state. Say for example, there are number of religious institutions, there are number of, say let us assume, temples in our country are managed by the state. In fact, the state governments of different state, they do manage a lot of temples. So, for example, there is a specific law in the state of Tamil Nadu which is called as the Tamil Nadu Hindu Religious and Charitable Endowment Act. Now, if you see under this particular act, there is a separate department in the state government of Tamil Nadu which manages more than 30,000 temples in the state of Tamil Nadu, and they are directly administered by the state. And for that matter, the state can recruit people to work in these religious institutions. Say for example, they may recruit a priest, Hindu priest, to work in a Hindu temple. And similarly, a Christian institutions might look for a person from a Christian religion, from Christianity, because only those people will be able to perform their duties effectively. So, in that case, if a particular post is reserved for a person belonging to a Hindu community to act as a priest in a Hindu temple, can it be seen as a violation of Article 16 of the Constitution, which says that there shall be no discrimination by the state when it comes to public employment on the grounds of religion? Well, that's a general principle, while Article 16 Class 5 is an exception. The exception says when it comes to religious institutions or religious denominations, even if it is under the control of the state, even if it is considered to be a public or it is considered to be a government job, still certain type of recruitment or certain type of jobs can be reserved to people belonging to a particular community or a religion. So, it is not seen as a violation of what is called as Article 16 in general, because this is an exception. Now, come to the next article, that is Article 16 Class 6. In fact, this Article 16 Clause 6 was inserted by the 103rd Constitutional Amendment Act in 2019. And what is this Article 16 Clause 6 is saying? Article 16 Clause 6 is saying that whatever we have seen in addition to Article 15 Clause 6, because the 103rd Constitutional Amendment Act in 2019, it has not only amended Article 15, it has also amended Article 16. It has inserted Article 15 Clause 6 in Article 15 and Article 16 Clause 6 in Article 16, which basically provides reservation for EWS community, or it basically provides for what is called as EWS reservation, but EWS reservation in what is called as public employment. So what is the difference between Article 15 Clause 6 and Article 16 Clause 6? Well, Article 15 Clause 6 gives reservation for the EWS community in the governmental educational institutions, or for that matter private educational institutions also. But whereas Article 16 Clause 6 provide up to 10% reservation for the EWS community in public employment, that is in the central and the state government jobs. So that is what is Article 16 Clause 6. But however, I said the 103rd Constitutional Amendment Act, which was brought in the year 2019, was challenged in the Supreme Court. And what was the ground on which it was challenged in the Supreme Court? That it was violative of what is called as a 50% rule that was brought in by the Supreme Court in the Indira Sani case. You see that it is violative of the 50% rule or not? Say for example, today if you talk of reservation, for the other backward caste, there is 27% reservation in jobs and also in the educational institutions. For the scheduled caste, there is 15% reservation. For the scheduled tribe, there is 7.5% reservation. On top of that, today EWS is also again giving 10% reservation. So if you add up, roughly it is equivalent to that of 60%, or to be exact, it is 59.5%. I am putting it roughly as 60%. So whether the 60% is it breaching the 50% rule that was set by the Supreme Court in the Indira Sani case? Of course, it might say that yes, it does violate the 50% rule set in by the Indira Sani case. So this is exactly why the EWS reservation was challenged in the Supreme Court. But however, the Supreme Court upheld the 50% reservation, or upheld the 10% reservation, EWS reservation. Because even in the Indira Sani case, the Supreme Court said the 50% rule is only a general principle. It doesn't mean that there are no exceptions. There can be exceptions to this 50% rule. And further, the Supreme Court said that this 50% rule is to be taken into account only for combining people from other backward caste, scheduled caste and the scheduled tribe. But today EWS reservation is a separate vertical. So similar to that of the other backward caste, similar to that of the scheduled caste and the scheduled tribe, this EWS is a separate vertical or a separate category of people who are getting the benefit of reservation. So that 50% rule is only for the OBC, scheduled caste and the scheduled tribes. And that 50% rule does not include the economically weaker sections among the general category. So this is a separate class of reservation, or this is a separate vertical of reservation, and hence it does not amount to breaching what is called as the 50% rule. Now saying this, the Supreme Court has upheld the EWS reservation both in the educational institutions under Article 15 Clause 6 for the economically weaker sections among the general category, and also in public employment up to 10% both in the central government and the state government jobs, up to 10% for the economically weaker sections in the general category. So this is what is the law of the land today. So it should be very clear in your mind what is Article 16. So Article 16 is basically talking about no discrimination when it comes to public employment. That is only part of Article 16, which is based on the principle of equality before law. But there are also articles like Article 16 Clause 3, 4, 5 and 6, which are based on the principle of what is called as equal protection of laws. I am sure it is quite clear to all of you. So with that understanding, we will move to couple of other two articles which are relatively smaller in terms of what we should know when it comes to the other articles, that is Article 17 and Article 18, which basically talks about what is called as abolition of untouchability. Now untouchability was a practice that was followed before the commencement of the Constitution, but the members of the Constituent Assembly thought if untouchability is to continue in our country, then that would not lead to what is called as the principle of equality, or untouchability goes against the principle of equality in the society, and hence untouchability should be abolished. And to abolish untouchability, the best way is that making it as a fundamental right, that anybody practicing untouchability would be considered to be a violation of the fundamental rights of the individuals. So that is what is Article 17 is saying. Article 17 is making it very clear the practice of untouchability is not only a violation of fundamental rights, but the practice of untouchability shall also be a punishable offence in accordance with law. That means Article 17 makes it very clear that nobody shall be subject to any practice of untouchability, which is not only a violation of their fundamental rights, but those who are practicing untouchability against any individual shall also be punished in accordance with the law. And to that extent, the Parliament can make law and prescribe the punishment to punish the individuals who are practicing what is called as untouchability. But however, the big question is, what is untouchability? So we'll come to that particular question as to what is untouchability. So Article 17 is making it very clear that neither the state or the private individuals. So Article 17 is both against the state as well as the private individuals. So neither the state shall not do anything or the private individuals shall not do anything which would result in what is called as the practice of untouchability. And what is untouchability is not defined in the constitution, but however various codes have given an interpretation that any form of disability, social disability imposed upon a particular individual because of a birth of an individual to a particular caste can be seen as a practice of what is called as untouchability. So normally when you go to rural areas, even today you can find that people are discriminated based on their caste. People are not allowed to enter into certain places. People are not allowed to sit. People are not allowed to wear slippers. People are not allowed to wear shirts. So these are all some element of social discrimination which others are entitled to, but they are not entitled to. Now all these things can be seen as a practice of what is called as untouchability. So neither the state, something that fall within the definition of state, nor any private individual shall engage in what is called as a practice of untouchability. And if they engage in practice of untouchability, it is basically that you are violating the fundamental rights of others who are subjected to untouchability, and for which you shall also be punished as per the law that is made by the Parliament. In line with the spirit of Article 17, the Parliament has enacted what is called as the Untouchability Offences Act 1955 to punish the people engaging in what is called as untouchability. But this law was not broader or very effective, and hence this law was amended and it was now renamed as what is called as the Protection of Civil Rights Act 1976, which is more competent and which is more effective than the previous version of the law. So today this Protection of Civil Rights Act prescribes a punishment for the practice of untouchability, and as per this Protection of Civil Rights Act, the practice of untouchability is both a cognizable and a non-bailable offence. I am sure that some of you might understand as to what is the meaning of cognizable and non-bailable offence. The combination of cognizable and non-bailable offence making it as a very serious offence. So the practice of untouchability is not a simple offence, it's a serious offence because it's a cognizable offence. Now what do you understand by a cognizable offence? Cognizable offences are those offences where the law enforcement authority or the police can arrest you without a warrant for a commission of such offence. Normally the police cannot arrest an individual without an arrest warrant. Basically it is a non-cognizable offence. That means in this case that the police cannot directly take cognizance because the offence is not so serious. So if directed by the court and if the court issues a warrant, then only the individual can be arrested. But whereas in case of a cognizable offence, there is no need for the court to issue a warrant because it's a serious offence where the police can arrest the individuals. So practice of untouchability is a very serious offence. Please keep this in your mind. And then it is also a non-bailable offence. So in fact, there is a saying which is called as bail is a rule. So when you say bail is a rule, whenever you are arrested, so normally the court is going to give you a bail because bail is your matter of right in most of the cases. But in case of non-bailable offence, bail is not a matter of right. Bail may be granted, but at the discretion of the judicial magistrate because it's a very serious offence. The gravity of offence on which you are arrested is very serious. So bail may be denied in this particular case. So that is what you'll have to understand as to what is the untouchability today and how the fundamental rights or part 3 deals with the subject matter untouchability. So I'm just repeating it again, just a moment. Neither the state nor any private individuals would do anything that would amount to what is called as the practice of untouchability against an other individual in our country. And if we are doing that, we are not only violating their fundamental rights, but we can also be punished for the practice of untouchability as per the law that is made by the parliament. This is the only way that the Constituent Assembly thought that the practice of untouchability can be eliminated, rooted out. And unless and until the practice of untouchability is rooted out in our country, the principle of equality cannot be established. And the way to establish that is to punish people who are practicing untouchability. And to that extent, the Parliament has enacted what is called as the Civil Rights Act, which prescribes that the practice of untouchability is both a cognizable as well as a non-bailable offense. Alright, so with that, we'll move to the last article that I want to discuss today, which is Article 18 of the Constitution. And with that, we are also coming to the end of the first theme of fundamental rights, that is right to equality. So what is abolition of titles under Article 18? Article 18 says that the state shall not confer title upon any citizens. The state shall not confer title upon anyone. In India, the state shall not confer title upon its citizens. So because titles are basically considered to be some honorary status or some rank which is conferred upon a particular individual, which gives them an element of not only the honor but superior status in the society. And these status are seen as violation of principle of equality, or it goes against the principle of social equality. For example, when the Britishers were ruling India, the Britishers were conferring the status of knighthood. They were conferring the status of Rajas, Maharajas, Nawab to certain categories of people, by which their social status was extremely high in comparison to that of the ordinary individuals. And there was no principle of equality that existed at that point of time, which continued to have some social discrimination in the society. But when the Constitution was drafted, the Constituent Assembly members thought that there shall not be any titles because we are moving towards the principle of what is called as equality. And to ensure that the state shall not confer any titles upon anyone. But however, some of the members in the Constituent Assembly had some concerns to put an absolute restriction on conferring titles. So some of the members said that there should be some exceptions on those areas where the state can confer the titles, except in the areas of what is called as academic and military titles. Academic means, say for example, somebody is given a title of professor, somebody is called as an associate professor. So that is all okay, doctorate. And similarly, the military titles for their distinguished service. Say somebody is given the title of what is called as general, major general. So all these things are okay. So except the academic and military titles, the state shall not confer any of the other titles under Article 18 of the Constitution. And that is not the end of Article 18. Article 18 says the state shall not confer any title upon its citizens except military and academic titles. And similarly, the citizens of India shall not receive any titles from a foreign country. Not only the Indian state shall not confer any titles, the Indian citizen shall also not receive any titles from a foreign country. But however, they are free to receive what is called as awards. And similarly, the Indian state is free to confer awards upon the individuals. So basically, title is seen as a rank. Title is seen as something conferring them a distinct social status, or title is conferring some kind of authority upon them. But whereas on the other hand, awards are merely an appreciation given to the individuals for their distinguished services in certain areas, probably in the areas of sports, in the areas of literature, or in certain other areas, in arts, whatever be it. So this is basically what is called as awards, or distinguished service that they have done towards humanity, whatever be it. So while the Constitution makes it very clear that the state shall not confer any titles, but it does not put any restriction on what is called as conferring awards. In fact, this matter was also taken up to the Supreme Court, that what about the various awards that is given by the government of India, like the Bharat Ratna, Padma Bhushan, Padma Vibhushan, Padma Shri. Can these awards are equivalent to titles? The Supreme Court of India in the Balaji Raghavan versus Union of India case very clearly said that the awards which is given by the government of India cannot be equated to titles, because these are given to the individuals for their meritorious service, and hence the government can continue to give these awards. But what the state cannot confer upon the individuals is that they cannot confer what is called as the titles, and the exception to that is only military and academic titles. The reason for this, as I already said, that this is the only way that the Constituent Assembly thought they can ensure what is called as social equality in the society. And further, the Supreme Court has clearly said that whenever the state confers these awards like Bharat Ratna, Padma Vibhushan, Padma Bhushan, whatever it is, the concerned individual should not prefix or suffix these awards to their names. They cannot use it as if it is like a title. No, it is just an award. So they should not prefix or suffix it to their names. And if they are prefixing or suffixing these titles to their names, then the award might be forfeited by the state. So this is what the Supreme Court of India has already held in this particular regard. So by that we are coming to the end of the right to equality, where you have covered Article 14, 15, 16, 17 and 18. So please go through all the lectures in an order for the maximum benefit out of all these lectures. And in case if you have any queries, you can reach out to me through my Instagram channel or through my Telegram account. But before we complete the lecture, so have a look into this particular question. So right to equality is covered under Article 14 to Article 19, Article 13 to Article 18, Article 14 to Article 18, none of the above. So if you know the answer, you can put it in the comment box, and I'm quite sure that all of you will know the answer for this particular question. And if you have any question related to the preparation in general or in relation to this particular topic that you have discussed, you can reach out to me through my Telegram channel or through my Instagram account. If you have any of your friends or family members preparing for the UPSC examination or any competitive examination, please refer them to watch these videos. It will be immensely beneficial for them, and I'm quite sure that it will help them in doing the exams extremely well. Thank you very much for watching this particular lecture. All the very best.